So नमस्कार all of you. हमारा जेएसओ प्रीलिम्स टेस्ट जोटा इंडियन एविडेंस एक्ट और भारतीय साक्ष्य अधिनियम सेटा हमें देखिबा दीटा पार्ट रे देखिबा क्वेश्चन 1 to 50 हमर इंडियन एविडेंस एक्ट संगे डील करछि और 51 to 100 डील करछि भारतीय साक्ष्य अधिनियम संगे ओके इंपोर्टेंट जिंसटा देखिबे क्वेश्चन रो जो एक्सप्लेनेशन देछि सेटा टिके भलो रे पड़े मु जनरली क्वेश्चन टा और कौन तार सॉल्यूशन हो सेटा डिस्कस कर देबे ओके बट यू गो थ्रू द एक्सप्लेनेशन को वाले तो बॉडी डेरी हिजबो सो कीप दैट इन माइंड ओके कहना बहुत गुडे क्वेश्चंस एतरे हमर प्रॉब्लम बेस्ड क्वेश्चंस अछि हला तो कांसेप्ट पूरा क्लियर करिया पई प्रॉपर्ली आपण एक्सप्लेनेशन भलो रे पढिबे एक्सप्लेनेशन रे जो पॉइंट्स पूरा देछि जदी कोटा बुझी पारलेनी ताले मते व्हाट्सएप करी जणेबे ओके so let us start question 1 to 50 Indian Evidence Act and deal with. Which of the following correctly states the principles governing admissibility under section 6 of the Indian Evidence Act? Okay, so directly hame answer statement ta hi discuss kar daba. I hope samaste test ta dei sari choti already. Okay, mu last week re kahithili test ta complete kar debe so that discussion re apno सुविधा हो. So जितने स्टेटमेंट्स देछि चारटा ता भितर कोटा ठीक हबो ओके तो देखंतु फर्स्ट स्टेटमेंट का एवरी स्टेटमेंट मेड आफ्टर अकरेंस ऑफ इवेंट ऑफ द इंसिडेंट becomes admissible if it relates to the incident okay every statement so if it relates to the incident okay so this is wrong BK assumes the statement is admissible under section 6 only if it forms part of the same transaction and is substantially contemporaneous with fact in issue. Okay, so eta apara correct answer. How one option ditla all hearsay statements become admissible if made before a police officer immediately after the incident. That is also wrong. Statements of witnesses recorded under section 161 CRPC automatically become part of res gesta. Okay. So आ भितरु बीटा करेक्ट आंसर होबो गोटे जिंस मन रखिबे केबे केबे क्वेश्चंस जेंति कि भारतीय साक्ष्य अधिनियम में रिटन दा क्वेश्चन अछि जो थरे आपन को लागिबो कि मल्टीपल आंसर्स आर करेक्ट ओके तो आपन देखियो सब इंस्ट्रक्शन में लिखा हिबो कि आ भितरे सबुठु माने करेक्ट आंसर कोटा सपोज आपन को लागुची ऑप्शन ए भी ठीक अछि ऑप्शन सी भी ठीक अछि ताले in that case you have to choose closest quota किंबा सबटु बेस्ट फिट quota सेटा हबो आंसर हला एटा गोटे जनरल जिंस मन रखिबे एमसीक्यू क्वेश्चंस पे काहे कि ना डायरेक्ट क्वेश्चंस जदि एबे न आसीबो और कॉन्सेप्चुअल क्वेश्चंस आसीबो ताले तारो जो देइथिबो ऑप्शन जोडा सेगुडा भी से माने कंफ्यूजिंग टाइप रो पकेबे एटा भी ठीक लागुथिबो बीटा भी ठीक लागुथिबो ओके तो जोटा सबुठु बेसी ठीक लागुची सेटा आंसर एबे क्वेश्चन 2 को आसंतु A is prosecuted for murder the prosecution alleges conspiracy between A B and C during investigation B made a statement to police after arrest narrating the entire conspiracy which of the following is most accurate regarding admissibility under section 10 of Indian Evidence Act. Okay. The statement is fully admissible against all conspirators because conspiracy once proved validates every statement. Okay. So that is wrong. Statement is admissible only against B and not against co-conspirators because it was made after arrest and during investigation. So that will be correct. See, the statement is inadmissible even against B because police statements are completely excluded under Evidence Act. Okay. Now the answer will be B is the answer. The statement is inadmissible against co-conspirators only if independently corroborated by magistrate's confession. Okay. So ये जो case law उड़ा दीजिए ना, एटा टिके भल्लोरे पढ़िबे. We don't have that much time. मु सेगुड़ा each and every question रो discuss कर पारनी. किंतु आपण को काम हला explanation टा भल्लोरे पढ़िबे. Okay. Question 3 क्या सर? Which of the following best explains the relationship between plea of alibi and section 11 of Indian Evidence Act? So, relationship between plea of alibi and section 11 of Indian Evidence Act. So, C ta tara correct answer dochi. Alibi is relevant because it makes the existence of the fact in issue highly improbable. Okay, can I say that out thila na? Sei jaga re crime scene re se thibo boli chances बहुत कम. Okay. So again, ATV same जिनसो आपण को तार explanation properly पढ़िबार अछि. एगुडा आपण एमति भाबिबेनी कि केवल प्री पेन दरकार. ए जो दोउची से तार explanation तार concepts सुडा आपण मेंस रे भी यूज करि पारिबे. जेमति केस लो आइ गला. Okay. Question 4 को आसंतु. One was stabbed inside a marketplace. Immediately after the assault, while bleeding continuously and running towards nearby shops, she shouted, "Ramesh has stabbed me." She became unconscious within 2 minutes. At trial, shopkeeper deposed regarding her statement, which is most appropriate legal position. Okay, so eta already upon janti. Okay, गोटे आपनकर जोटा लीडिंग केस लॉ. ओके, एग्जैक्टली सेटा को इंडियन ना देकी रिप्रोड्यूस कर दे. आर वर्सेस बेडिंगफील्ड. ओके, so the statement is admissible under section 6 as part of the same transaction. Okay, eta on the queue. So जोटा केस लॉ टा कोट कर. Which of the following statement regarding relevancy under section 8 and 11 of Indian Evidence Act is incorrect? Preparation for commission of an offence is always irrelevant unless independently criminal. Okay, so this is wrong. Rest of all are correct. Question 6 question 2. Which of the following statements most accurately distinguishes an admission from a confession under the Indian Evidence Act? So every confession is an admission, but every admission is not a confession. Okay, so it's a direct question for you. Question 7 question 2. A filed a suit against B for recovery of money. During negotiation, B wrote, "Without prejudice, I may settle the matter for ₹5 lakhs to avoid litigation." A seeks to produce this letter as admissibility of liability. What is the correct legal position? So the statement is inadmissible because it falls within protection of section 23 relating to admissions in civil cases upon express condition. Okay. Question 8%. Which of the following correctly states the effect of section 31 of the Indian Evidence Act? So, admissions are not conclusive proof, but may operate as estoppel under certain provisions. Actually, केमिति आपन को यूज करिवार अछि गोटे टेस्ट सीरीज आपन तो डिटेल्स दिया हला आपन तो लाइव टेस्ट भी देले कि एटा भी पीडीएफ टा देखिले आदर नोट्स बने पड़ियो आपण एमती भाबतु खाली मु मोर स्क्रोल करदेली पढ़ीदेली गोटे रीडिंग करदेली तो काम होगा नहीं यही पर्टिकुलर केस रे किंबा यही पर्टिकुलर पॉइंट रे यही केस रे ओके एटा इंपोर्टेंट केस तेणु सेटा आपको लिखा पड़ो नोट्स सेटा प्री पाई भी आपको हेल्प हो मेंस पाई भी आपको हेल्प ओके क्वेश्चन 9 A was prosecuted for murder during interrogation by a village officer having substantial police powers. A stated, I alone killed X with a knife and buried the weapon near the canal. The weapon was later recovered from that location. Which of the following is most accurate? Okay, so C, only the statement regarding location of weapon is admissible to the extent distinctly relating to discovery. So that is option C. Okay. Question 10 question. P sued Q claiming ownership of ancestral property. During earlier revenue proceedings, Q had signed a statement that P share in the property. In the present suit, Q argues that the admission was mistaken and cannot be considered. Which of the following is the best legal position? Okay, so the admission is relevant and substantive evidence, though not conclusive proof. Question 11 question. Which of the following statement regarding section 24 of the Indian Evidence Act is correct? अच्छा जो मैंने YouTube रे करी देखुछन आउ आपण को एक्सेस नै पीडीएफ को तो आपण पॉज करि दियो पॉज करी कि फर्स्ट पढी दियो यदि आपण प्रिपेयर करछंती ताले पढी दियंतु आउ ओके अटेम्प्ट करिया पे चेष्टा करो. So which of the following statement regarding section 24 of Indian Evidence Act is correct? Okay, so A is the correct answer. A confession caused by inducement, threat or promise from a person in authority becomes irrelevant if it appears sufficient to give accused ground for supposing advantage or avoidance of evil. Question 12. A and B were jointly tried for Dacoity and murder. During trial, A's confession before magistrate implicated both himself and B. There was weak corroborative evidence against B. Which of the following is most appropriate legal position under section 30 of Indian Evidence Act? So B is the correct answer. The confession may be taken into consideration against B, but cannot by itself form sole basis of conviction. Question 13. A was arrested for murder and while in police custody stated, I concealed the blood-stained axe beneath the banyan tree near the river. Police recovered the axe from that exact place. Which portion of statement is admissible? Exactly same thing what I just dekhiଥିଲୁ. Okay, so A will be the correct answer. Only the portion distinctly relating to discovery of axe beneath banyan tree. Only that much is okay admissible. So the coaching mari dechi seta admissible. Right? Question 14%. Which of the following statement correctly explains the scope of section 25 of Indian Evidence Act? So C is the answer. Section 25 renders every confession made to police officer inadmissible irrespective of voluntariness. Question 15. During investigation of counterfeit currency case, accused X stated before customs officer empowered with search and seizure powers. The fake notes are hidden inside blue suitcase in my warehouse. The notes were recovered exactly therefrom. Which of the following is the best legal position? Okay. So B is the correct answer. That fully same question. At minimum, the part relating distinctly to discovery of fake notes may become admissible under principles analogous to section 27. Now come to question 16. Which of the following statement regarding dying declaration under section 32(1) of Indian Evidence Act is correct? A truthful, so this is A is the correct answer, a truthful and voluntary dying declaration can form the sole basis of conviction even without corroboration. Okay, but seta kama kahila truthful ହେଇଥିବା ଦରକାର, voluntary ହେଇଥିବା ଦରକାର. Question 17. A woman suffering from severe burn injuries gave a statement before a doctor identifying her husband as assailant. The doctor certified that she was conscious and mentally fit. No magistrate was called due to emergency. Which is the most appropriate legal position? Okay. So doctor certify kale ki siye conscious thila aur mentally fit thila dying declaration daba pai. So a vitru quota thik. The statement is admissible and may form basis of conviction if found reliable. Okay. Then question 18%. Which of the following correctly explains the scope of 32(1) of Indian Evidence Act? Okay. So your answer is option B. Statements relating to cause of death are relevant in both civil and criminal proceedings whenever cause of death comes into question. Okay. Tapare, question 19. A was attacked with acid and admitted in hospital. She gestured by nodding towards accused B when police asked who attacked her. The doctor certified she was unable to speak but conscious and understanding questions. She died 2 days later. Which is the best legal position? So C will be the answer. The gesture may amount to valid dying declaration if properly understood and proved. Question 20. During trial for dowry death, prosecution relied upon 2 dying declarations of deceased wife. In first declaration before neighbor, she stated accidental stove burst caused burns. In second declaration before magistrate, she accused husband and in-laws of pouring kerosene. Medical evidence showed kerosene traces on body and floor, which is the most appropriate approach. Okay, so D is the correct answer. Court may evaluate surrounding circumstances, medical evidence, and reliability of each declaration before determining evidentiary value. Okay. Inconsistent dying declarations. Multiple dying declaration ଦେଇଛନ୍ତି ଆଉ ସେଗୁଡା ନିଜ ନିଜ ସାଙ୍ଗରେ match କରୁ. Okay. Next 21%. Which of the following statement regarding expert evidence under section 45 of Indian Evidence Act is correct? So A is the correct answer. Expert opinion is advisory in nature and is not binding upon the court. (22%) A disputed will allegedly executed by X was produced before court. The handwriting expert opined that signature on will matched admitted signatures of X. Which of the following is the most accurate legal position? So B, handwriting expert opinion is relevant, but prudence requires corroboration from other evidence. Question 23. Which of the following statements correctly explains the scope of section 45 and 46 of Indian Evidence Act? Facts supporting or inconsistent with expert opinion become relevant under section 46. Okay, C is the correct answer. Question 24. A was prosecuted for murder. Fingerprints found on murder weapon matched A's fingerprints according to fingerprint bureau expert. During trial, defense argued that conviction cannot rest only on expert evidence. What is the best legal position? So reliable fingerprint expert evidence may form important incriminating evidence, though court must assess surrounding circumstances carefully. Question 25. In prosecution for cyber fraud, the prosecution relied upon digital forensic expert who testified that deleted emails recovered from accused laptop showed fraudulent transaction. Defense argued that expert opinion alone cannot establish authorship of emails, which is the most appropriate legal position. So, electronic expert evidence is relevant under section 45A, and court may consider it along with surrounding evidence regarding authorship and control. That is the correct answer. So we'll just take a break for 1 minute, 26 to 50. Okay, after that we will continue. Okay, let us continue then. Question 26 question. Which of the following statements correctly explains the relevance of character evidence in civil proceedings under Indian Evidence Act? Okay, so A is the correct answer. Character evidence is generally irrelevant in civil cases unless character itself is directly an issue or affects damages. (27) A was prosecuted for cheating under IPC. During trial, defense led evidence that A had an excellent reputation for honesty and integrity in business community for 30 years, which is the best legal position. So B is correct. Evidence of good character is relevant under section 53 as circumstances favoring innocence of accused. Number 28 question. Which of the following statements regarding section 54 of Indian Evidence Act is correct? So C, bad character becomes relevant only after accused has himself given evidence of good character subject to statutory exceptions. Question 29. A filed a defamation suit against newspaper alleging publication damaged his reputation. Newspaper sought to prove that A was already widely known for fraudulent business dealings before publication. Which is the most appropriate legal position? So B will be the correct answer. Evidence regarding plaintiff's bad reputation may become relevant in mitigation of damages under section 55. Question 30. During murder trial, accused X adduced evidence of his peaceful and law-abiding nature. Prosecution thereafter produced certified copies showing X prior convictions for violent assault. Defense objected, claiming previous conviction is irrelevant to present charge, which is the best legal position. So once the accused, B is the correct answer, once the accused give evidence of good character, prosecution may rebut it through evidence of bad character, including prior conviction, were legally irrelevant. CA प्रथमे देथिला accused. Okay, कि मो character बोलो. Right. 31%. Which of the following statement regarding primary and secondary evidence under the Indian Evidence Act is correct? So, option A is the correct answer. That is, secondary evidence is admissible only after foundation for non-production of primary evidence is established according to section 63 and 65. A sought to prove contents of a registered said deed by producing certified copy obtained from sub-registrar's office. Opponent objected, arguing that original deed must first be produced, which is the best legal position. Okay, certified copy of registered document may be admissible as secondary evidence in circumstances recognized by law. Question 33. Which of the following statements correctly explains proof of arrested documents under section 68 of Indian Evidence Act? C is the correct answer. Where law requires attestation, at least one attesting witness must be ordinarily be called to prove execution if available. 34. A disputed promissory note allegedly signed by B was produced before court. Handwriting expert gave opinions supporting genuineness of signature. Court itself compared admitted signatures with disputed signature under section 73 and disagreed with the expert, which is the most appropriate legal position. So court's comparison, option B, under section 73 is permissible, though it should exercise caution while acting as its own expert. Question 35. During trial relating to forged government notification, prosecution produced original Gazette publication from official archives and certified copies issued by government press. Defense argued that only officer who drafted notification could prove it, which is the best legal position. So C will be the correct answer. Government gazettes are public documents and certified copies thereof are admissible under section 74 and 77. Question 36. Which of the following statements regarding section 65A and 65B of Indian Evidence Act is correct? So A will be the correct answer. Electronic records produced in evidence ordinarily require compliance with conditions under section 65B for admissibility when presented in secondary form. Next, 37 question. A prosecution sought to rely upon CCTV footage copied into pen drive by investigating officer. No certificate under section 65B accompanied the pen drive. Defense objected to admissibility, which is the best legal position. So option B is the correct answer. Absence of section 65B certificate may render secondary electronic copy inadmissible unless case falls within recognized exceptions. Question 38 was on which of the following correctly explains the distinction between relevancy and admissibility regarding electronic evidence. Relevancy concerns logical connection with fact in issue, where admissibility additionally requires compliance with legal conditions such as 65. 39%. During corruption trial, prosecution produced original mobile phone containing incriminating audio recordings. The phone itself was seized and presented before court. Defense argued the absence of section 65B certificate, making the recordings inadmissible, which is the most appropriate legal position. Okay, so C will be correct. Where original electronic device itself is produced and proved, requirement of certificate may not apply in same manner as secondary electronic copies. Question 40. A matrimonial dispute involved WhatsApp chats allegedly showing cruelty by husband. Wife produced screenshots printed from her phone along with certificates signed by her describing devices and print process. Husband argued certificate invalid because only service provider could issue it. What is the best legal position? Okay, so D is the correct answer. A person occupying lawful control over device and manner of production may furnish valid Section B certificate if statutory requirements are satisfied. Okay. 41. Which of the following statements regarding burden of proof under Section 101 to 103 of Indian Evidence Act is correct? So A is the correct answer. The burden of proof initially lies upon the party who substantially asserts affirmative facts necessary to obtain judgment. Question 42. A married woman committed suicide within 4 years of marriage. Evidence showed persistent cruelty and dowry-related harassment by husband shortly before death. Which is the most appropriate legal position under the Indian Evidence Act? Okay, so A will be the correct answer. Court may presume absence of suicide, abatement of suicide under Section 113A upon proof of cruelty by husband or relatives. Question 43. Which of the following correctly explains Section 106 of Indian Evidence Act? Okay, so C will be the correct answer. When any fact is especially within knowledge of a person, burden of proving that fact lies upon him. Okay, so that would be the correct answer. Question 44. In prosecution for custodial death, evidence showed deceased was last seen alive inside locked police interrogation room accessible only to accused officers. Officers failed to explain injuries found on deceased. Which is the best legal position? So A will be the correct answer. Failure of officers to explain injury may permit court to draw adverse inference under Section 106 read with Section 114. Question 45. A child was born during subsistence of valid marriage between H and W. H denied paternity and relied solely upon allegation of wife's adulterous conduct without proving non-access. Which is the most appropriate legal position? So D. Child born during valid marriage is conclusively presumed legitimate unless non-access between parties is proved. 46. Which of the following statements regarding estoppel under Section 115 of Indian Evidence Act is correct? Okay, so A would be the correct answer. Where one person intentionally causes another to believe a thing to be true and act upon it, he cannot later deny that truth in proceeding between them. Question 47. A prosecution witness during chief examination supported prosecution story, but in cross-examination denied material facts and claimed police pressure. Prosecution sought permission to cross-examine its own witness. Which is the best legal position? C is the correct answer. Court may permit party calling witness to cross-examine him under Section 154 if witness appears adverse. Question 48. Which of the following statement correctly explains the rule relating to accomplice evidence under Indian Evidence Act? So D is the correct answer. An accomplice is a competent witness, but prudence generally requires corroboration in material particulars. Question 49. During murder trial, Defense counsel repeatedly asks leading question in examination in chief of defense witness without court's permission. Prosecution objected, which is the most appropriate legal position. So leading questions may generally be asked only in cross examination unless court permits, otherwise in examination in chief. Last question of Indian Evidence Act. In a corruption trial, judge actively questioned witness regarding unexplained financial entries and recalled witnesses for clarification despite objection from both prosecution and defense. Which is the best legal position under Indian Evidence Act? So B is the correct answer. Judge may ask any question at any stage to discover relevant facts subject to statutory safeguards and fairness. Okay. So एटा हला हमारा फर्स्ट पार्ट इंडियन एविडेंस एक्ट रो 51 रो 100 टा हला भारतीय साक्ष्य अधिनियम रो जोडा कि हमें नेक्स्ट सेशन रे ताको डिस्कस करियो. ओके, एज आई टोल्ड यू जो माने जॉइन करि सरचंदी आपण टिके सब क्वेश्चन रो एक्सप्लेनेशन ता भलरे पढियो हला. एटा बहुत इंपोर्टेंट. ते एक्सप्लेनेशन रो आ गोटे क्वेश्चन भी आस जे पारे से क्वेश्चन ता न आसी. एक्सप्लेनेशन ता पढिबा टिके टाइम आपन को लागे. ईच 100 क्वेश्चंस पाई धरंतु 2 रु 3 घंटा लागिवो आपण जदी तार एक्सप्लेनेशन भलरे पढिबे बुझिबे. इफ यू हैव एनी डाउट्स यू कैन व्हाट्सएप मी. ओके, सब कुछ पढि लिखि देबे सेटा कि क्वेश्चन रो इम्पैक्ट का पूछ करबे. सो नेक्स्ट क्लास रे नेक्स्ट सेशन रे हमें 51 to 100 एटा देखिबा which basically deals with भारतीय साक्ष्य अधिनियम. So we'll stop here then. Thank you.